Welcome to City Speak. I'm your host, Stephanie Martinez-Ruckman, and I'm the Legislative Director for Human Development at the National League of Cities. City Speak gives listeners an insider's view of what local leadership in America means today and features conversations with government leaders and policy experts regarding the biggest issues and challenges facing America's cities, towns, and villages. Just as NLC works with the legislative and executive branches in our federal advocacy to advocate on behalf of local governments, we also fight on behalf of cities, towns, and villages when relevant issues come up before the Supreme Court, filing amicus briefs to help make sure judges understand how their rulings may help or hinder local governments. As you may know, the Supreme Court recently wrapped up a memorable term in July, and their decisions will have big impacts for America's cities, towns, and villages. We saw rulings on local government tax foreclosure and the amount of equity that is due back to a homeowner after a tax sale. We saw eviction law and redistricting issues, law enforcement issues, including qualified immunity and geofence warrants, birthright citizenship, and the Second Amendment. So today, our guest on City Speak is here to explain what those decisions meant for local governments and local leaders. I want to welcome back to City Speak Amanda Karras, the Executive Director and General Counsel of the International Municipal Lawyers Association. In her role, Amanda oversees IMLA's legal advocacy efforts with the Supreme Court, circuit courts, and state appellate courts. She has authored numerous amicus briefs, including at the Supreme Court merits and petition stage, as well as in federal circuit courts, in addition to her previous experience in private practice. And most importantly, Amanda has been a strong partner to NLC with our ongoing legal advocacy efforts as a founding partner of the Local Government Legal Center. Amanda, welcome to City Speak.
It's great to be here, Stephanie. Thanks for having me.
Of course. Before we jump into the big cases, for those who may not be aware, can you talk a little bit about what the Local Government Legal Center is and how you're working closely with NLC to ensure local governments have a voice before the Supreme Court?
Absolutely. So the Local Government Legal Center is a coalition of national local government organizations, which was formed back in 2023 to provide education to local governments regarding the Supreme Court and its impact on local governments and local officials. We also advocate before the Supreme Court for cases and issues that are going to impact local governments. One of the things we do is we try to help shape those cases by filing amicus briefs at the Supreme Court, and we provide effective and persuasive advocacy through those briefs and help educate the justices on the issues that are going to be most impactful for local governments. NLC and IMLA are both founding members of the Local Government Legal Center, along with the National Association of Counties.
Awesome. Well, I have to say it's been a wonderful partnership over these years. The years fly by. Let's dig into this term and start with what is perhaps the biggest case of the term for local governments, Pung versus Isabella County, which could have had devastating impacts for local governments. Can you walk us through the case and what the impact is for local governments?
Yeah, well, you're right. This was the case for local governments. And unless you were paying close attention to the Supreme Court, it would have been easy to miss this one, just given everything else that was happening at the court. But as you said, for local governments, I think this was the true blockbuster. So the issue in this case centered on tax foreclosures and how much money is owed back to a property owner who is delinquent on their taxes when their home is foreclosed on by the government. In this case, the property owner argued that the government violated the Fifth Amendment's takings clause as well as the Eighth Amendment's excessive fines clause when it sold his home at a tax auction after he failed to pay his taxes and then only returned the difference between the tax auction price and the tax debt. He argued he should have been given back the fair market value minus the tax debt. So, if you break down the numbers in this case, I think it really tells the story. The property owner had a $2,000 tax debt. After he failed to avail himself of the various processes under state law to avoid foreclosure, the county ultimately foreclosed on the property and sold the property at an auction for about $78,000. The county kept the $2,000 debt, returned $76,000. And we know, as you'll recall, after Tyler versus Hennepin County, that local governments have to return the surplus equity when they foreclose on a home. So they did that. But here, Mr. Pung argued that he was actually owed something like $195,000 minus the $2,000 debt, because he said that's what his home would have fetched on the fair market. Had it been sold kind of at a normal traditional sale, he thinks it would have gotten something like $195,000. That was the assessed value. So obviously, this claim that he was somehow owed the fair market value minus the tax debt would have been devastating for local governments had the court accepted that rule. Most tax auctions fetch far lower prices than what you might get, if you were to sell your home, right? And there's a lot of good reasons for that. It's not nefarious. A lot of times, these homes, the local governments can't even go inside of them to take pictures and to see what the condition is. It varies by state law, but it's much harder to get a higher price at a tax auction. And again, there's a variety of reasons for that. And homeowners can avoid these situations through state law mechanisms in many cases. So at any rate, it's really hard to overstate what the financial consequences of this decision would have been had the court agreed with the petitioner. So I'm happy to report that in a huge win for local governments, the court rejected those constitutional claims. And, this is one of the first wins for local governments in a takings case in a very long time. And I know you and we talked about this a lot when the case was first granted, but we were very concerned that the court was taking this case. There were some sympathetic facts for the homeowners, which is always worrisome when the court takes a takings case, again, just because of that sort of losing streak at the Supreme Court that we've had. But fortunately, the court rejected this notion that somehow fair market value is owed in these situations. Justice Alito wrote the majority opinion and held that the takings clause does not require the government to use fair market value as a baseline when it sells a foreclosed property at a tax auction and only returns the surplus proceeds above the outstanding tax debt. The court also rejected the excessive fines argument. Now, the court did leave open the possibility that there could be some questions around fairness of the underlying process of an auction. And so it remanded the case to the lower court to make sure that the process itself was fair. So the bottom line for cities is to understand that if a city forecloses on a property based on a tax delinquency and then sells the property at a tax auction, so long as the auction is procedurally fair, and so long as the city returns the proceeds to the homeowner after keeping the tax debt, what is owed, there should be no constitutional problems. Our amicus brief, I think, was very effective in this case. It wasn't cited, but when you read the majority opinion, it really seemed to have adopted a lot of the arguments that we made in that brief. So I was happy to be able to advocate for local governments in this case.
We'll take that a win when they repeat our arguments, whether they cite us or not. So that's great.
Exactly.
And I know you're right. As you say, it's the facts in these cases that we sometimes get caught up in rather than the legal questions, or at least mainstream media does. And I think really digging into sort of what these questions are for local government and why you are so important to help us understand all of that. Another big case of the term was Trump versus Barbara around the issue of birthright citizenship. The LGLC didn't file in a brief this case, but it is a case that would have resulted in likely increased burdens for local governments that provide critical service to residents in their communities, as these children would no longer have been eligible for federal benefits like TANF and WIC. And it would also created some uncertainty for local governments as to how vital records should be administered for children born to parents lacking legal status going forward. So really important to understand sort of where this case leaves us. So could you walk us through the court's decision on this case?
Sure. And I think, probably most listeners are aware of the court's holding. This was, kind of the big media headline case. But as you said, this case could have had serious consequences for local governments. And, I think the court issued a decision in what I would call pretty sweeping language. The Chief Justice wrote for the majority and struck down the executive order that purported to end birthright citizenship. The decision rested on the 14th Amendment's citizenship clause. So just briefly backing up, I think folks are all aware, on the first day of President Trump's second term, he issued Executive Order 14160, which was entitled Protecting the Meaning and Value of American Citizenship. That order provided that babies born to individuals who were in the United States either unlawfully or temporarily would not qualify for citizenship under the 14th Amendment or under the Immigration and Nationality Act. Now, just a reminder for folks, if you haven't broken out your Constitution lately, the first clause of Section 1 of the 14th Amendment says, and this is the quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And then there's a provision of the INA which basically parrots that language. So, predictably, after this executive order was issued, there were a number of lawsuits. You'll remember the Casa decision actually went up to the Supreme Court last term as a result of some of those lawsuits on the question of nationwide injunctions. And the court held that district courts generally lack the equitable authority to issue nationwide injunctions. So, when the cases went back down, what the courts did was they certified a class, which was one of the options left open after Casa. So the executive order had been enjoined by a district court. It certified a class of all children who would be denied citizenship under the executive order. And then that's how it came up to the Supreme Court in that posture. So the Trump administration sought review on both the question of whether the order violates the 14th Amendment or whether it violates the INA. So interestingly, 5 justices agreed with the Chief Justice writing the opinion that the executive order violates the 14th Amendment. Justice Kavanaugh would have struck down the executive order based on the INA, but not the Constitution. So, kind of depending on how you look at it, and we talked about this, is it a 5-4 decision? Is it a 6-3 decision? And it's kind of both. Turning back to the majority, the court held that the text of the 14th Amendment was clear, and a child born on American soil and subject to American law was made an American citizen. The court, as with so many other areas of the law these days, looked back to history, relied on English common law, all the way up through the enactment of the 14th Amendment, which was enacted in the aftermath of the Civil War. And that amendment was a specific response and repudiation of the Dred Scott decision, which is widely considered one of the court's most disgraced decisions. The Dred Scott decision of 1857 held that African Americans, including those who were free, were not included and were not intended to be included under the word citizen in the Constitution. The Chief Justice in the Barber decision explained that Congress sought to permanently enshrine the common law in the Constitution and put the great question of citizenship beyond legislative power altogether and settled the issue once and for all. So I mentioned the sweeping language. I'll just read one line that I think captures that. The Chief Justice wrote, here's the quote, "Citizenship then and now was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every freeborn person in this land. We keep that promise today." I'll just conclude by mentioning, there's already been a lot of ink spilled over sort of the different writings in this case. And what does it mean that 5 justices struck down the order based on the Constitution, whereas, you didn't have more than that? You can kind of look at that in different ways. So I think on the one side, you could say, well, only 5 justices struck it down. So does that mean, the future, somebody could sort of try this again? And I think that's a valid question if the makeup of the court changes, in the next several years or decades. On the other hand, you could say that the justices didn't have to decide the constitutional question. There's something known as the doctrine of constitutional avoidance. So generally speaking, the Supreme Court, if it can answer a question in a way that avoids sort of analyzing the Constitution, it tries to do that. But here, there were presumably 6 votes to strike this down under the INA, and instead we got 5 striking it down on the constitutional basis, which I think does put this issue more to bed. You can imagine if they just wrote that it violates this congressional statute and didn't talk about the Constitution, we'd probably have a lot of debate in Congress over this right now.
Yeah, totally. I'm just imagining that conversation. And for those not familiar, INA, Immigration and Nationality Act. So that's, as you were saying, Amanda, right, would be putting it back to Congress, but striking down versus the Constitution is bigger. To keep it in the big cases bucket, the other big case of the term was, of course, the redistricting case, Louisiana versus Calais. And again, the LGLC did not file in this case, but the result of the court's opinion is a narrowing of the Voting Rights Act, which would remove checks and balances on partisan-driven redistricting. So this is really big. And so can you talk about what the impact of this Calais decision it means on redistricting and specifically what that means to local governments?
As you said, this case resulted in a significant narrowing of the Voting Rights Act. And I think it will likely feel, and frankly, we've already seen this, a lot more partisan gerrymandering. And that's going to impact local governments in a variety of ways, which I'll talk about. So the issue in this case was whether Louisiana's intentional creation of a second majority minority congressional district violates either the 14th or 15th Amendment of the Constitution. So to understand what happened here, let me just back up briefly. Louisiana drew new congressional maps in the wake of the 2020 census. This resulted in one majority Black district, despite the state's population being roughly one-third African American. So a group of voters sued, claiming that this new map violated Section 2 of the Voting Rights Act. District court agreed with them, said the map likely violates the VRA, Voting Rights Act, and ordered the state to draw a map with two majority Black districts. And the Fifth Circuit actually affirmed that. So the state, following the court's order, draws new districts with two majority Black districts. Now, fast forward, a new group of individuals sue the state, claiming that this new map, and these individuals are not, they describe themselves as non-African American voters. They claim that this new map, which was ordered to comply with the VRA, actually violates the Constitution, and specifically the 14th Amendment's Equal Protection Clause. So the case goes up to the Supreme Court. I won't bore you with all the back and forth procedural history, but in a 6-3 opinion, the Supreme Court held that Louisiana's map was an unconstitutional racial gerrymander. In doing so, the court significantly modified the test for deciding whether a map violates the Voting Rights Act. And the court held that a Section 2 claim under the Voting Rights Act will succeed only where evidence supports a strong inference that the state intentionally drew its districts to afford minority voters less opportunity because of their race, and not other non-racial factors like partisan advantage. And that's really the crux of this. And the dissent points this out, that basically the dissent argues that this decision all but destroys Section 2 of the Voting Rights Act because, basically, if you can explain the map based on partisan advantage, that's going to pretty much defeat a Section 2 claim. And a plaintiff has to be able to somehow disentangle race from politics and from partisanship, which at the moment is very difficult to do in a lot of these districts, right? And so I think that's why the dissent claims that, you're basically making it impossible to bring a Voting Rights Act claim. The other sort of big change now is the focus is on the legislature has to be intentionally discriminating against, voters based on their race. Historically, under the Voting Rights Act, we'd be looking at the effects and whether there's sort of vote dilution on a particular voting block, a minority voting block. So going back to your original question, what does this mean for cities? I think it's complicated. First, as I've said, and you said, this case pulls the ripcord on partisan gerrymandering, and it really supercharges it. And that can impact cities because state legislatures may seek to divvy up a city and divide up a city in a way that it really never would have. Because, traditionally we look at keeping communities together as one of the sort of factors in these cases. And you can just look at what happened in Memphis as an example of that, right? I think the other thing is cities can be targets of VRA lawsuits. I don't expect that to change because of this decision. It's possible there may be fewer successful lawsuits against cities since Calais makes these decisions or these cases harder for plaintiffs to succeed on. But I think, and you know this better than I do, but I think many cities don't run partisan elections, right? So I think it's going to be harder for cities to claim that a particular map was based on something other than race if, the claim is race-based redistricting when it's a nonpartisan election. You can't claim, well, I was doing it because of partisan advantage if you guys are not running on a party platform. I do think we'll see more lawsuits kind of in the wake of this decision just to kind of test the contours and figure out what it all means.
Yeah. And just really quickly for local leaders, this case talks about congressional districts, but when we're thinking about state districts, councilmatic districts, this applies to everybody, right? So this is any kind of redistricting.
Absolutely. Yeah, this will apply to any kind of redistricting. Right. I couldn't agree more.
Shifting a little bit here to law enforcement, this term the court had two law enforcement cases. They had more than two, but two cases that the LGLC filed briefs in, Chatry versus the United States and Case versus Montana. Law enforcement issues, as you know, are central to local government operations. And both of these cases address very different but interesting legal questions. Could you walk us through those?
Let's start with Chattree. This case concerns a geofence warrant that was sent to Google. And, if you don't know what a geofence warrant is, it's basically where law enforcement will draw a circle on a map around an area that they want to get information about. And they in this case, send that geofence off to a magistrate judge to get a warrant. And then they send it to Google and they want information about that, who was in that circle within a certain period of time before and after a particular event. Now, the way the geofence warrant process works with Google, there's a 3-stepped process. I can't say I fully understand it, but there's this back and forth between law enforcement and Google where things sort of get narrowed down. The information is initially anonymized. The law enforcement goes back and forth with Google, and they eventually get sort of zeroed in on particular individuals that they're interested in. This case has to do with an armed robbery that occurred in Virginia at a federal credit union. The initial investigation didn't yield any suspects. So then a detective applies for a geofence warrant from a Virginia circuit court. And then they get that over to Google. And, the result of that geofence warrant, which followed that 3-step process that I mentioned, was that they had a suspect and they ultimately arrested him for this armed robbery. Now, he sought to suppress the information obtained from that geofence warrant, which was, basically all of his cell phone location history, right? So when we think about our cell phones come with us everywhere we go, right? Most of us anyways. And your cell phone is often tracking your location. There was some discussion in this case. It was interesting. Theoretically, that is something that is voluntary, at least in the Google process. And they talked about this in the briefs. Well, you're voluntarily giving this information over to Google in terms of your location history. But I guess the way it works with Google is it keeps prompting you over and over and over again to turn on location history. And it'll tell you, like, your phone's not going to work properly if you don't do this. And all these applications aren't going to work. So there's sort of a feeling like, is it voluntary? Is it not voluntary? But there was an argument here by the federal government that he had turned this information over to Google voluntarily. So part of the question in this case was, is that even a search? Because, if you give something, there's something known as the third party doctrine. If you tell a third party, in this case, Google, something that you don't want law enforcement to know, you can't then complain that that third party turned it over to law enforcement. That's the theory, at least. So he was trying to argue that, his basically overturn his conviction because he was saying this whole process was unlawful and it violates the Fourth Amendment. The specific question the Supreme Court took in this case was whether the geofence warrant was reasonable under the Fourth Amendment. But to answer that question, they have to figure out if this was a search because, the Fourth Amendment only governs searches by the government in this case. So as I said, the U.S., the federal government argued this wasn't a search because of what's known as the third party doctrine. And there's other aspects of the case, but that's what I'm going to focus on here. So the Supreme Court rejected that argument. It was a 5-4 decision authored by Justice Kagan. And she said this is a search, even though he, quote unquote, voluntarily gave this information over to Google. And it seems like the court really carved out here sort of an exception to the third party doctrine, or really just we have to think about our cell phones as just fundamentally different when it comes to the third party doctrine, because the court talked about how, this truly wasn't voluntary. And the court said, and this is a quote, a cell phone user is not to be viewed as sharing private information with third parties, which then can be freely passed on to the government just by doing the ordinary things cell phone users do. So I think what was interesting about this opinion is really we can kind of think about the court providing added sort of privacy interests for individuals when it comes to their cell phones. And law enforcement really can't access your information from that cell phone, whether it's, your location history, your imagine emails, documents, photos, right? That you could potentially get from Google or Apple or some other third-party provider. Maybe your information's all in the cloud somewhere. You really cannot access that without a warrant. Now, remember, this case is all about whether the geofence warrant was reasonable. The court didn't answer that. They just decided to totally punt that back to the lower courts. We didn't get an answer. They just said, we decided that this is a search, and the lower courts can figure out whether the warrant was reasonable. So unfortunately, I think it would have been helpful to law enforcement to better understand, whether these types of warrants are going to hold up when they're challenged in court. And we don't have a great answer here. But we do know that at a bare minimum, you're going to have to go get a warrant in these situations. And if you don't, law enforcement can be sued. Obviously, in this case, it was a motion, seeking to sort of suppress the information in a criminal trial. We care because it can lead to liability later on, right? So that's part of our interest in these cases. The other law enforcement case you mentioned that we were involved in involved a suicidal individual and questions around when law enforcement can enter a home without a warrant when they're engaged in their emergency aid or community caretaking functions rather than the detection of a crime, right? So normally you need a warrant to enter a home, and there's a few exceptions to that. And, what do you do in a situation where somebody needs help and you're not trying to, investigate if there was a crime there? You just need to go in and help that person. In this case, the individual was suicidal, as I mentioned. The girlfriend of Mr. Case had called and sort of indicated various factors that would tell law enforcement that he was potentially going to commit suicide. When they went to the home, there were indications that he may have committed suicide or was about to, kind of a holster without a gun. It looked like a note. And so they're, knocking on the door. They can't get in. They eventually decide to enter the home without a warrant to try to assist him. Unfortunately, in the process of doing so, he was behind a curtain. He sort of startles an officer. He pulls the curtain back and reaches for a gun. The officer shoots him. He fortunately lived, but was then charged with, crime related to an assault of the police officer for reaching for the gun. He argued the officers never should have been in his home without a warrant. And so at the Supreme Court, Mr. Case was advocating for a standard that the Fourth Amendment prohibits warrantless searches in these situations absent criminal probable cause. The problem with that is that if that had been the standard, it would have made it very difficult for officers to render emergency in these situations because, you can only get a warrant if you're trying to investigate a crime. And here, again, there's no crime. They're just trying to help him. Fortunately, the Supreme Court rejected that argument and held that the Fourth Amendment allows police officers to enter a home without a warrant if they have an objectively reasonable basis for believing that someone inside needs emergency assistance. And that standard was met here. So this is a nice win for law enforcement. It provides officers with latitude when they're operating in these community caretaking functions, and it will also decrease liability for local governments.
Staying on this theme of law enforcement, the court also issued a decision this term in Zorn v. Linton, which is a favorite local government topic of qualified immunity. So liability for cities, as you've mentioned here already today, as it pertains to any issue, is a top concern for local leaders, but especially in law enforcement. Can you tell us about this case and its impact on local governments?
Yeah, absolutely. Qualified immunity cases, as you said, are really important. And I know our members, are familiar with the doctrine and understand its importance. This case is known, was a summary reversal, and it's pretty rare. I'll kind of talk about that in a minute, but it's worth mentioning here at the top. This occurs when the Supreme Court doesn't actually hear a case at oral argument. It just reverses the lower court without sort of further briefing. And I mention that too, because I'm sure the local government legal center would have wanted to file in this case had the court actually heard the case, but it just reversed the lower court without that opportunity. So this was a 6-3 decision, reversing the Second Circuit's denial of qualified immunity for a police officer who was alleged to have engaged in excessive force based on his use of a rear wrist lock on a non-violent protester. So in this case, we have a group of about 200 protesters. They had staged a sit-in during the January 2015 inauguration of the then Vermont governor. When the Vermont Capitol closed to the public that evening, police officers informed the protesters they would be arrested for trespass if they didn't leave. So most of them left, the vast majority left, but around 30 protesters stayed. At that point of the 30, some are sort of escorted out without force, but others like Miss Linton here refused to stand and leave. And she was, sitting with her arms interlocked with other protesters, and they had to be forcibly removed. So with Miss Linton, again, she's got her arms interlocked with other protesters. The officer comes over, has already asked her to leave, and he unlinks her arms from the other protester and puts her in a rear wrist lock, twisting her arm behind her back. He repeatedly asks her to stand up. Please stand up. She responds, I will not stand up. and uses the rear wrist lock to put pressure on her wrist and lifts her by her underarm. She's, kind of jerky on her feet and ultimately has to be escorted out and carried out, I think, by several officers. So she sues for excessive force under Section 1983. The district court granted qualified immunity, but the Second Circuit reversed, and the Second Circuit denied qualified immunity, relying on a case from that circuit that concluded it was clearly established that the gratuitous use of a rear wrist lock on a protester passively resisting arrest constitutes excessive force. So that was kind of what had happened up until the Supreme Court. The Supreme Court summarily reverses the Second Circuit, concluding that the case the circuit court relied on did not actually clearly establish the law. The court re-emphasized the need for specificity to make it clear to officers which actions violate the law. And the court emphasized the officer had given repeated warnings about the impending force, and she continued to resist. So I think a couple things to note here. Number one, just the mere fact that this was a summary reversal provides, I think, strong support for law enforcement when we're litigating these cases in lower courts, that qualified immunity continues to offer robust protections for officers. Plaintiffs really have to find a sufficiently similar case on point to clearly establish the law and put officers on notice that their conduct is unlawful. Part of the problem with the case they had relied on here at the Second Circuit was it involved a rear wrist lock, but it involved a whole lot of other allegations of excessive force too, and the court kind of lumped it all together. So, again, the Supreme Court is saying, no, you have to find a case that is very factually similar. And I think this ruling also will help local governments limit liability in cases involving rear wrist locks. So, again, a really great win for local governments in that case.
I think you're right. I think qualified immunity, had the court heard this case, we definitely would have wanted to file in this case. Shifting a little bit here, another thing local governments utilize is administrative subpoenas, right, to investigate potential wrongdoing in their communities as they seek to safeguard the health and welfare of their constituents. So in the case First Choice Women's Resources Centers, Inc. v. Davenport, the court looked at whether constitutionally based challenges to state or local administrative subpoenas can be heard in federal court before state proceedings have concluded. So that's a lot of words. In plain language, what does this case mean for local governments?
Yeah, administrative subpoenas, it sounds like it might be something a little bit boring, but I assure you these are really important tools that local governments utilize to really try to safeguard their communities from potential corporate wrongdoing. So I'm just going to tick off a couple of examples from Chicago alone that we talked about in our brief. So Chicago subpoenaed a student loan company that was allegedly engaged in fraudulent business practices. The city issued subpoenas to landlords who defrauded a city program seeking to help renters struggling during the COVID-19 pandemic. And the city issued subpoenas to e-cigarette companies that were illegally marketing products to minors. The purpose of these subpoenas is before litigation, the local government is investigating whether these companies are potentially violating the law. It allows them to sort of figure out, are they going to go further and actually sue? So the concern in this case was that there was a state procedure in place for how to challenge a subpoena that was issued under New Jersey law and in New Jersey court. And what happened here instead was the petitioner ran to federal court before even complaining in state court, or really before the state even sought to enforce the subpoena. Because when you get the subpoena, it doesn't mean anything yet. The state has to go in and try to enforce it. So this was basically, our concern here was that, if you agreed with the petitioner that you can just run to federal court in these cases, it would make it harder for local governments to investigate potential violations of state and local law. It would increase litigation and costs for local government by having to now defend litigation in federal court when all they were trying to do is figure out if this corporation was harming its residents. So the Supreme Court held in this case that a Section 1983 suit challenging a subpoena issued by the New Jersey Attorney General demanding documents and donor information, that in that case, First Choice had established a injury sufficient to its First Amendment associational rights to allow it to bring this suit in federal court. So this was technically a loss for state and local governments, but I'm just going to explain why I think it's a fairly narrow loss. This case centered on donor lists that New Jersey wanted from First Choice Resource Center, and the court's analysis ended up really hinging on the fact that these were donor lists that the state wanted, and there was a real potential to chill First Choice's First Amendment associational rights because of the specific information it was seeking here regarding donor lists. So I think this decision could really be limited to kind of that class of information. And if the subpoena isn't about donor lists or, something else that might sort of chill First Amendment associational rights, then I think hopefully the decision will be fairly narrow and less impactful to local governments.
So this term, the court also issued two decisions in Second Amendment cases, in Wolford v. Lopez and in United States versus Hamani. While I don't think we should cover these cases in detail, it does point to an increase in Second Amendment cases before the court, including the Viramontes versus Cook County case. That's the AR-15 ban case, the much anticipated case that the court will hear next term. So can you give us a little sneak peek, a little preview of key cases impacting local governments that we know are already teed up for the court next term?
Yeah, absolutely. And as you said, next term's already heating up with some really interesting cases for local governments. You mentioned the AR-15 ban, which is definitely one we're going to want to follow. In addition to that, the court has agreed to hear a case involving the intersection of religious exercise and zoning. This case is Grand versus City of University Heights. It involves an individual who wanted to hold religious prayer in his home with others in the community, and he sought a variance to have a religious assembly in his home, which was zoned residential. Before he could complete the process seeking a variance, he withdrew his request, but then sued a little bit later, claiming a chill of his First Amendment rights based on some statements made by the mayor and some community members at his initial hearing. Given the importance of zoning processes, this is going to be a case we're going to want to watch. Another important case is Suncor versus County Commissioners of Boulder. This actually involves the city and county of Boulder. This is a preemption case involving Boulder's climate change lawsuit. Now, while there are many of these climate change lawsuits percolating in the lower courts, I think the real interest in this case and sort of the broader interest is the preemption angle. So the oil companies have made very broad preemption arguments, which could impact other areas local governments litigate in. Anytime there's a potential preemption case at the Supreme Court, we're going to be interested in those cases given the importance of local autonomy. And preemption is basically about taking power away from local governments. The court's also going to hear a challenge to a state's universal pre-K program under the Free Exercise Clause in St. Mary's Parish versus Roy. This case could implicate a host of local government programs involving neutral laws of general applicability that religious entities may challenge. And then lastly, sort of an interesting headline-grabbing case involving questions of a state's criminal forfeiture of an airplane over violations of state law prohibiting the importation of alcohol to certain dry communities in Alaska, or what those headlines like to claim, the forfeiture of an airplane over a six-pack of beer. Obviously, it's more complicated than that, and that case is Jaupi, another name I'm not sure how to pronounce, Jaupi versus Alaska. And, local governments can be involved in criminal forfeiture cases, so that's another case we're interested in.
Great. Well, we'll do a little tease here for our preview webinar that will come as we get closer to the start of a term. But Amanda, thank you so much for joining us on City Speak. You really have a way of cutting through these really dense legal proceedings to get to what really matters for local leaders. And as our CEO Clarence likes to say, you are our legal eagle. So we look forward to continuing to partner with you on this important work. So once again, thank you to our listeners for downloading and listening to City Speak.
Thanks for listening to City Speak with Clarence Anthony. If you like this show, let us know. Share this episode with your friends and make sure to subscribe. We're curious to hear what you think, what you want more of, and how we can improve. If you have feedback or an idea for a guest you'd like Clarence to sit down with, send us your thoughts at cityspeakpodcast@nlc.org. Join us next month for a new episode. Like and subscribe here or wherever you get your podcasts. See you next time.